We're all familiar with prenups, but when do such agreements violate public policy, particularly if states are committed to protecting marriage as an institution? The 1976 California case of Marriage of Dawley examines this question in the context of a shotgun wedding. Betty Johnson and James Dawley were intimately involved for a few years. In 1964, Betty learned she was pregnant. As a teacher, she was concerned about the consequences at work if she had an illegitimate child. Betty ultimately convinced James to enter into a temporary marriage, though James insisted on a prenuptial agreement. Betty agreed as long as James agreed to support her and her daughter Carolyn from a previous relationship for a period of time after Betty gave birth. James agreed, and James's attorney drafted the agreement, which Betty's attorney reviewed before Betty signed. The agreement provided that anything acquired by either spouse before or during the marriage would be owned as separate property and that both parties disclaimed any rights in the other's property, including community property rights. The agreement also stated that James would support Betty and Carolyn for a minimum of 14 months after they married so that Betty could take a leave of absence from work after delivering the baby. He also agreed to support any child until the age of majority born to Betty in the subsequent 10 months. Betty and James signed the agreement on June 11, 1964, and were married 2 days later. Their daughter Lisa was born in January of 1965, and the 14-month period ended in September of that same year, at which point Betty returned to work. However, the couple didn't separate and ended up staying together for the next 7 years. In 1973, James filed for divorce in trial court. The court granted the divorce and, relying upon the prenuptial agreement, found no community property to divide. It awarded Betty custody of Lisa and ordered James to pay Betty $300 a month for child support. Betty appealed, claiming the agreement was invalid and contravened public policy. As a result, she contended that she was entitled to a division of the couple's community property.